Aloha, everyone. Well over 400 people registered for today's discussion regarding Hawaii's new eviction mediation requirements, and we appreciate you all joining us. We have a lot of great material to cover in just 60 minutes, so let's get to our agenda. So, why are we all here today? On February 5th, a new mediation requirement goes into effect for certain eviction cases. Now, some of our attendees were already aware of this, while others probably just heard about it. And that's totally okay, because we're going to go over those details. We'll then host a panel discussion with our judicial and mediation partners, so everyone is better informed on the entire process. Additionally, we're grateful to have Catholic Charities join us to share financial assistance resources for our tenants in need. And finally, we'll close with providing contact information for the speakers or their organizations. I also want to remind everyone that guest speaker involvement does not imply endorsement by the courts or mediators. This is for general educational purposes and not intended to be legal advice. Okay, so before we jump into everything, we at Pacific Housing Association want to thank our speakers for the opportunity to help facilitate this session. For those of you who aren't familiar with PHA, we are fully led and managed by volunteers. In fact, this entire presentation and everything was put together by volunteers. PHA is the affiliate for the National Apartment Association and partner of the Affordable Housing Management Association of Northern California and Hawaii. Our network helps connect Hawaii rental housing providers to national best practices, whether it's for general operations or affordable housing management resources. In Hawaii, our organization helps support over 20,000 long-term rental homes across 3 islands. And our membership is comprised of market rate, affordable, workforce, student, and military rental housing. PHA serves members ranging from individual owners who own or manage one single unit, all the way up to thousands of units for organizations that are managing throughout the state. And of the many resources we offer, we really aim to assist our members by providing education, compliance, and training tools to help enhance our long-term rental housing industry throughout Hawaii. This supports both housing stability and the development of new rental housing, including much-needed affordable rental housing. So let's discuss Hawaii's new mediation requirement. Last month, PHA hosted a 2026 legal seminar with attorney David Chee, which brought together more than 100 attendees from both the public and private sectors throughout Hawaii. At this seminar, Mr. Chee introduced a new mediation requirement, but soon after, we received a lot of requests for more guidance and specifically, how can we actually work through this in reality with everything? So therefore, today's session aims to reduce the confusion and support informed participation as the new law takes effect. Our panel discussion will be structured as follows. Firstly, we'll cover the steps required under the new law. Then we'll cover what participants can expect from the mediation process. Thirdly, we'll discuss how cases may proceed if mediation is unsuccessful or the timeline is not followed. Then we'll jump into notice and filing timelines. And then lastly, we'll cover practical compliance considerations. As with most large system-wide changes, with a lot of different moving parts, there will be a lot of questions we're anticipating. Therefore, feel free to submit your questions in the Zoom Q&A. We will work together to compile those and issue a frequently asked question breakdown for everyone. I also want to note that today's shared information is based on what we know as of today, January 28th, 2026, and it could change. Again, this is not legal advice. We have multiple attorneys and a judge on this call, so I have to hit all these legal disclaimers with everybody. So now it's time for the main event. We're grateful to have the following speakers join us today. David Chee, attorney at law, Honorary Melanie May, District Court Judge, State of Hawaii, Tracy Wilkin, Executive Director of the Mediation Center of the Pacific, and Danny Jella, Catholic Charities, Hawaii. David, happy to turn this over to you. Please take it away.
Gotta unmute first. So thank you. Thanks, Jesse. I can imagine that, the reason for today's seminar is to sort of dispel some confusion. The people were probably confused because I was the speaker at the last one. But in any event, this is what we have for the on the agenda for today. I'm planning on running through some of the fundamentals of the new law that is about to be implemented. But I'm going to start off with the who, what, where, when, and why of the new law. But I'm going to start off with the what. And so the what is that there's going to be a fundamental change in the law regarding uh, evictions and non-payment disputes between landlords and tenants on the residential side. And this law is going to be in effect for the next 2 years. I'm thinking that the plan was to see how it works for 2 years, and if it works really well, then I'm sure that there'll be more legislation to extend it. If it doesn't work so well, then I expect it might go back to the way that things are presently. But it's a 2-year law. And like I said, it applies to residential non-payment evictions. It doesn't apply to any of the commercial evictions or any other type of evictions, such as termination at the expiration of a term lease. If somebody gives a 45-day letter to end the month-to-month tenancy, or an eviction based on bad behavior. So the this only is going to affect the residential non-payment situations. So the changes that you're looking at for the law is basically going to require that landlords talk to tenants before they file an lawsuit. And so presently, the way that it works is that when you want to, if a tenant hasn't paid the rent, the landlord can give a particular notice to the tenant. And once that notice time is expired, the landlord can go ahead and file the eviction lawsuit. This new law is going to switch things up, where the law is now going to require that the landlords offer to mediate with tenants before they can file an eviction lawsuit. Generally speaking, that's what the requirement is going to be. And so that's what we're talking about today, is this new change in the law and how this is going to work. So that's the what. So the who part of things is, who does this apply to? This applies to pretty much everybody in the state of Hawaii, but in particular, I'm imagining that the people who are here on this webinar are here because you're involved somehow in residential housing. And so for the folks who are involved in residential housing, this is going to affect you because if you are, for example, a property manager or a landlord, then you need to know what you need to do in order to move forward with a matter if a tenant doesn't pay the rent. If you're on the tenant side of things, you're going to need to know, what to expect under the new law and what the procedures are going to be going forward. So that's the who part of things. The when part of things is February 5th. The new law is going into effect on February 5th. So that's not very far away. And so you have to start making plans for that now. Um, and the where part of things is, of course, the entire state of Hawaii, because this law affects the entire state of Hawaii. But it actually affects each circuit slightly differently in that the notices that would need to be distributed under this law are going to be slightly different depending on which circuit you're in. There's going to be different notices that are going to be released by the judiciary for everybody to use, but you got to make sure that you use the right one for your particular part of the world. And the last thing about is why, why this new law? And the best answer I could come up with was because the legislature said so. So that's why we have this new law. But it's really based on Act 57. If you'll recall, during the pandemic, Governor Ige imposed a moratorium on evictions, and that moratorium lasted for about 2 years. And the concern in the legislature was that as soon as the moratorium ends, that there would be a quote unquote tsunami of evictions that would occur. And that tsunami would swamp the court system and just leave many, many people homeless. And so, uh, in anticipation of that, there was a lot of thought and effort put into coming up with a program to prevent a sort of a mass eviction situation. And so, although the today's situation is a bit different in that we're not coming out of a moratorium or anything like that. One of the things that worked very well out of Act 57 was that a lot of agreements got made through mediation because Act 57 required mediation, much like this new law will be doing. And so under Act 57, landlords needed to agree to participate in mediation before they had an opportunity, before they filed an eviction lawsuit. And similarly now, under this new law, that's what's going to need to happen is an offer of mediation needs to occur before an eviction lawsuit can move forward. Let's see. And there are a couple of, significant advantages to having mediation happen before the eviction lawsuit gets filed. First one is that there's a significant potential to avoid attorney's fees and costs, so it can be a lot less expensive for people. The other thing is that if when people mediate, it can often save the relationships because you're not throwing them into an adversarial process where everybody has to, basically fight it out. And so mediation is, can be a much more cooperative process, and you can get results that perhaps work better for everybody. Um, and it can minimize the amount of stress and difficulty, especially for people who are not familiar with the court system. So, for example, the mom and pop um, landlords out there or the individual tenants, many people have never had any experience with the court system before and would much rather just sit down and talk with the mediators to try to get things resolved. And so that's what mediation brings that the court system by itself would not. So those are the primary benefits that you can expect. Um, and so what I wanted to do now is basically explain kind of some of the fundamentals and the nuts and bolts of the new law. The new law is going to be a modification of what is now HRS 521-68. So you're going to see that law change. And and I wanted to just kind of say one of the reasons that I put this seminar together was because I wasn't exactly sure what was going to be happening when the new law went into place. And so I wanted to pick Tracy's brain and Judge May's brain. And I figured one way to get everybody to talk about what was actually going to happen was to see if I can get everybody to do a seminar. So I wanted to thank them for agreeing to do this. Uh, so here's what to expect um, with the new law. Uh, the purpose of the law, as I said before, is to encourage landlords and tenants to work out their problems by themselves without the court's involvement. And so the primary way of doing that under this new law is by requiring that uh, landlords provide to tenants a notice um, with respect to their debts. And Jesse, can I have the slide that shows the 10-day notice? Thanks. So the law helpfully had a requirement in it that the judiciary issue a form of notice that can be provided to tenants, and it's called the 10 calendar day notice. And the Supreme Court actually issued one version of it, which I understand is primarily the one that's going to be used for Oahu. And I think that, as I understand it, different versions are going to be issued for different circuits. But the one that's on the screen right now is the initial version that was released. Um, and this can be downloaded from the judiciary and used by landlords in order to give notice to tenants that um, uh, that they owe money and to initiate this process. Um, when this I think that what's going to happen is once everybody has had an opportunity to actually get this particular form, I'm going to suggest that everybody read the form and all of the blanks that are in the form are things that need to be filled in. You're going to see that in the form is very heavy on contact information for the landlord and for the tenant. And Tracy is going to be talking more about um, this particular form and what the mediation center is going to do with it. But the thing that most people need to understand is that once the form has been filled out and been it needs to be given by the landlord to the tenant and also at the same time uploaded to the mediation center. And Tracy will go through the nuts and bolts of how to upload and where to upload these forms. So with respect to this 10-day notice, this is going to be the new notice that needs to be used starting on February 5th. If you have your old 5 business day notices, you should put those away because you're not going to be able to use them um, for the next couple of years. And so there's a couple of highlights on the form I wanted to point out. One of which is that in the form, and it's in the law, it says that the landlord is required to mediate if a mediation gets scheduled. So the reason that I wanted to highlight this is because if on the landlord side of things, um, once you send out one of these letters and you submit this to the mediation center, the landlord is committing to mediating. So the landlord really has to think about it as to whether or not they actually want to mediate before they send out this letter. So, for example, if a tenant owes some small amount of money, say, $300 on rent, the landlord's going to need to have to really think about whether or not they want to send out this letter and then spend the time and the effort to go through mediation over that $300. It's really the question's going to be whether or not this is the right mechanism for dealing with that problem. But that's something that I think landlords have to consider for themselves and looking at their own practices as to whether or not they want to do that. Um, and as I've mentioned,
Hey,
there
hey,
is a
David,
requirement. Yes.
quick time check, about 8 minutes left.
Oh, okay. Thank you. And the other thing that I wanted to make sure that everybody understood is that uploading of this form at the same time that the notice is given to the tenant is going to be required. Part of the deal here is that the mediation center is going to be under a certain amount of time crunch to get mediation scheduled because of what's going to happen with respect to this notice. After this notice gets uploaded, the this is a 10-day notice that tells the tenant you've got 10 days to pay your rent or number one, pay your rent, or number two, initiate mediation. And if the tenant pays the rent off, then you're done. But if the tenant initiates mediation, um, then then what happens next is that the tenant is going to be given an additional 10 more days to resolve the problem before the landlord can start up an eviction lawsuit. So rewinding just a moment because I don't think I said that very well. On this 10-day notice, if the tenant is given 10, well, once the tenant is given the 10-day notice, if the tenant simply does not respond to the notice, after that, the landlord is able to file an eviction lawsuit. If the tenant pays off, of course, then you're done. If the tenant doesn't pay off, but instead contacts the mediation center or the mediation center contacts them and schedules mediation, then the landlord has to wait an additional 10 days, so 20 days total from the time the letter is given. The landlord has to wait 20 days before it can file an eviction lawsuit. And so that way, I, I know that in Act 57, when that was being generated, the idea was that they wanted to give tenants an incentive to contact the mediation center and to engage in mediation, and they figured that more time would be that an incentive to do that. So when you look at this, this at how this is set up, it's to encourage tenants to mediate. And since the landlords are required to mediate, you don't need to encourage landlords because it's already statutorily required. So the idea is that more time is given to a tenant before a lawsuit is brought so that mediation can occur. Now, if the tenant schedules the mediation, then the landlord has to wait 20 days before filing the eviction lawsuit. The fact that the mediation hasn't occurred yet, is scheduled but hasn't occurred yet, doesn't affect the timeline for filing of the eviction lawsuit. You can file the eviction lawsuit 20 days after the tenant is initially given the notice, regardless of whether or not the mediation has taken place. So wanted to explain that so that you can keep that in mind. Um,
You want to hit the complaint form as well too, David?
we can move over to the complaint form. So I did want to mention that if the tenant does schedule the mediation and then thereby gets the additional 10 days, but then cancels the mediation or doesn't show up for the mediation, then you don't need to wait 20 days before you file the eviction lawsuit. You still have to wait the 10 days because, you told the tenant they have 10 days to clear the debt, but you don't need to wait the 20 days if the mediation gets canceled or the tenant doesn't show up for the mediation. So we can go now to looking at the complaint form. Jesse, could we move over to the sort of the first page? There you go. That's fine. So as everybody probably knows, I'm not sure if everybody knows, but the court issues forms of documents for parties to use. One of the forms that the district court has issued is this complaint form. I'm not sure if it's actually available yet to be downloaded, but this is going to be the new complaint form uh, that is going to be available for landlords to use so that they can initiate eviction lawsuits if, number one, the mediation is unsuccessful, or number two, mediation was successful, there's an agreement, but then the tenant doesn't comply with the agreement, or number three, if you've independently come up with a settlement agreement or some payment plan or whatnot with the tenant and they violated it. This is the form that you would use to start up an eviction lawsuit. Um, we did a seminar with the collection law seminar section, at which the court staff enunciated all of the very many reasons that you should be using the court's forms when you are filing anything to the extent that the court has a form. So if you are in the area of practice of evictions or dealing with summary possession claims, you should take a careful look at the court's form to make sure that you know what it says and how to fill it in. I did want to say that there are a lot of blanks on the court's forms, and maybe Jesse, we can kind of zoom out. Thanks. So there's a lot of blanks, and I'm going to say that pretty much in my review of this form, I'm pretty sure that you're going to have to fill in all of these blanks. So you're going to want to make sure that you have reviewed this form and understand what needs to be filled in, so that when you file your complaint is complete. So my first tip for this, for what to do with filing a complaint, is going to be read the form and understand it. Um,
2 minutes.
Thank you. A couple of things that you're going to need to attach to the complaint. One is the 10-day notice. that we've talked about previously. And another thing that you're going to need to attach also is the proof that the mediation center is going to be providing to you that you have uploaded the form. If you don't have the proof that you uploaded the form, you're not going to be able to move forward with your complaint. So you got to show that you uploaded the thing to the mediation center. But keep in one thing to note is that under the new law, if you've somehow lost your receipt from the mediation center, you can ask them to give you a new one. So let me give you a couple things that I wanted to flag about the new law. Um, and one is that you don't actually need to go through mediation and to file an eviction lawsuit if you have a separate agreement with a tenant that's been breached. So if you have already come up with an agreement with a tenant as to a payment plan or something like that and it gets breached, you don't need to go through mediation. You don't need to do the 10-day form. You can just go straight and file an eviction lawsuit. I want to emphasize again that landlords must participate in mediation. Don't send out this 10-day notice. Don't upload it to the mediation center unless you're planning on actually participating in mediation. Um, and so, um, and one other thing about the new law is that there's, with respect to mediation, one of the concerns I think that for the new law was that um, lawyers did not want to be trapped in an endless cycle of mediation where you go to mediation, you file the lawsuit, and then the court sends you back to mediation again and again. I'm not saying that happened a lot, but I know that it happens sometimes that litigants get sent back to mediation more than once. One of the things to know is that if your eviction lawsuit is based on the breach of a mediated agreement, the statute says that the court is not supposed to send you back to mediation again. If it's not based on the breach of a mediated agreement, then you could be sent back to mediation, but only for good cause. I think that takes care of me, Jesse, and we can turn it over to Tracy now.
All right. Thank you, David.
No, thank you.
Tracy, take it away.
Thank you. Aloha, everyone. Thank you for joining us today. Next slide. I am going to go through some slides. Next slide. So a little repeat, and then I will go into the nuts and bolts. So as you heard, under Act 278, when a landlord wants to file for eviction, they must provide a 10-day notice to the tenant. And as you heard David say, simultaneously, so you post it on the tenant's door or you mail it to the tenant, the notice must also be provided to the community mediation center on the island where the rental property is located. And we, the community mediation centers throughout the state, have created a one-step system to make this as easy as possible. Next slide. So once you go to the judiciary's website and create your notice and provide it to the tenant, you can go to a centralized website of Mediation Centers of Hawaiʻi. Mediation Centers of Hawaiʻi is the umbrella organization for all the community mediation centers throughout the state who the judiciary has contracted with to provide services under the Act 278 program. So once you've created your notice, you can go to Mediation Centers of Hawaii's website. The link is in the PowerPoint. You'll also be provided today, I believe in the chat, a flyer for landlords, a flyer for tenants, and a list of FAQs. Those documents will also have the link for this website in it. And you can go to the Mediation Center of the Pacific's website, and we will have a link that will connect you to this website. So this is the website you need to go to. First step is creating your notice, giving it to the tenant. Second step is coming to this website. Once you get to Mediation Centers of Hawaiʻi, or MCH's website, you can create, you will be asked to complete a form. It's a fillable form, and attach the notice to the form and upload it to the website. Once you have done so, you will receive an automatic electronic confirmation that says you've met your responsibility under Act 278 of submitting the notice to the appropriate mediation center. that website will direct the notice to the mediation center where the rental property is located. So you go and create your notice, and then you go to this website. There's a form to fill out on the website. You attach the notice, upload it. It will direct your notice to the appropriate mediation center, and it will provide you with a form stating that you met your responsibilities. Because as you heard David say earlier, if you do end up and go to court, you'll have to provide proof that you met the requirements of the notice. And so this is the automated response that you'll be getting once you upload the form and the notice. Next slide. So when you complete the information at the website, please ensure that all information is correct. So take your time, review it before sending it so that we have the correct information. The names and contact information of everyone, attorneys, authorized agent, property manager, needs to be on there, and their contact information. Also, please include any accommodations that are needed to participate in mediation. That could be an interpreter. Maybe you need some kind of special tech support, whatever that is, if you can let us know on that form. And please remember, if you have more than one tenant that you are evicting, it's one form and one notice for each tenant. And then you upload these through the website. Next slide. So when a tenant receives a notice of eviction, the tenant has 10 days to reach out to the mediation center on the island where the rental property is located. As you heard David say, if the tenant hasn't requested mediation within the 10-day period, the landlord may proceed with eviction. Next slide. When a tenant receives the notice of eviction, they must request mediation within the 10-day period. So they should immediately call the mediation center on the island where the rental property is located. The tenants can go to the same MCH website, the link I already provided. The contact information for all the mediation centers is listed on that website. Tenant or landlord may request an interpreter to assist with the scheduling process as well as during the mediation. A tenant will be required to provide specific information to the scheduler of the mediation center they contact, including when the notice was received. So that's the timeline starts running. They need to provide their availability to mediate. Mediations are scheduled Monday through Friday between 8:30 a.m. and 5 o'clock p.m. There may be, depending on which island, there may be some Saturdays. Although I understand most property managers don't want to mediate on Saturdays. It's up to the landlord and the tenant or whoever is representing the landlord. The mediation center scheduling the mediation can provide technical assistance to participate in the mediation. Mediations are primarily via Zoom. So if a landlord or a tenant says, well, I don't have the right bandwidth or I don't have the right equipment, they can request to go to the mediation center on the island where the rental property is located and use that center's equipment. Alternately, if somebody is really uncomfortable mediating via Zoom, they may request to mediate in person. And the scheduler, once they have talked with the tenant to find out tenant's availability, they'll reach out to the landlord to finalize scheduling a mediation. And remember, the sooner you get it scheduled, the sooner you can participate and ideally reach an agreement. But if you don't, then the landlords within that 20 calendar day period can move forward with the eviction process. So it's really in the interest of both tenant and landlord to schedule a mediation as quickly as possible. Next slide. Once a mediation is scheduled with the tenant, the landlord and tenant will be electronically notified of the date and time of the mediation session and provided with a Zoom link. Again, we're trying to make this as easy as possible for everyone. So remember, Zoom links, oftentimes your notices will go into the junk folder. So please check your junk email for notices. If the tenant doesn't participate in the scheduled mediation, the landlord may move forward with the eviction. So it's important, I don't know if there's tenants in the audience or people working with tenants, to remind tenants is once they schedule that mediation session, they need to participate. If not, then the landlord can move forward with the eviction process. And certainly it's up to landlord and tenant if they decide they want to reschedule, but the landlord does have that right. Next slide. As I mentioned, mediations are conducted virtually via Zoom. In order to do so, tenants and landlords must have a desktop, a laptop, or a smartphone with a microphone and a camera. You need the microphone and the camera to participate. And you need internet access and sufficient bandwidth. I know in some areas the bandwidth is not always the best. And so if you don't have any of those, you want to schedule using a room and equipment at the mediation center on the island where the rental property is located. And again, you can also mediate in person if you're really not comfortable with the virtual mediation process. Next slide.
Tracy, 8-minute mark too, just a heads up.
Thank you. Okay, next slide. So how to prepare. Mediation is a great process, but it's up to the participants to make it work well. We have great mediators, but that's not the only formula. You really need to come prepared to mediation. So organize your information and your documents, such as the lease agreement. How much is owed? Think about a realistic payment plan or other possible new living arrangements. Check into those first before you go into mediation. So that's important. The more organized you are, the better the outcome in the mediation. Talk with an attorney before you participate, and think about potential outcomes. What can you do? What's a reasonable timeline? What are your plans? Next slide. How the mediation works. So first, a confidentiality agreement will be emailed to the tenant and the landlord to sign electronically prior to the mediation. The confidentiality agreement reinforces that the mediator isn't going to go talk about what they've heard. You can't subpoena the mediator to court, and any offers of settlement in the mediation are off the table if you do end up in court. So only finalized written agreements that are signed are not confidential. Again, an interpreter will be provided if English is not the tenant or landlord's primary language. Mediation sessions are scheduled for 1.5 hours. Sometimes they don't take that long. You might end sooner, but we want to give you enough time to talk through all your issues. Landlord and tenant typically start together with the mediator. This is irrespective of whether you're in person or you're in a virtual mediation. However, if you're very uncomfortable being in the same room when the mediation is scheduled, you can ask that you be kept separate throughout the mediation, and that will be respected. If either landlord or attorney are represented by an attorney, they can have the attorney participate, but they're both responsible for their own attorney's fees. Next slide. What happens in mediation? Well, mediators ask lots of questions. We don't tell you what to do. We're not going to advise you to do something, but we ask lots of questions to help the two of you talk with each other and share potential agreements. So certain questions might be, what circumstances led the tenant to getting behind on their rent? What's the tenant's plan for paying the outstanding rent? What circumstances have changed that will enable the tenant to pay the rent moving forward? And if the tenant can't agree to a realistic payment plan, what options have they looked into for relocating? Next slide. Mediator will ask landlord questions as well. What's important to them? Covering the lost rent or having the tenant move out and never recouping the back rent? What was the relationship like with the tenant prior to the tenant getting behind on the rent? What's their definition of a good tenant? If they could recoup all of the back rent and the tenant could pay the rent moving forward, would they consider renewing a lease with the tenant and keeping the tenant? So we want to ask lots of questions to get you thinking about a variety of possible solutions. Next slide. And the mediator will help the landlord and tenant negotiate an agreement. Next slide. Agreements. Next slide. Okay. A mediation agreement will keep the landlord and tenant out of court and avoid the eviction process. Next slide. Next slide. Oh, well, yes. Okay. The landlord may move forward with the eviction process if the tenant doesn't attend the mediation or fails to meet the terms of the agreement. Next slide. And landlords must submit the 10-day notice to the website at mediationcentersofhawaii.org. And when a tenant receives the notice, they should immediately contact the mediation center on the island where the rental property is located. And that's all I have. Thank you. And these are the contact information for the mediation centers. It's also up on the Mediation Centers of Hawaii's website.
And Tracy, I'll email out the forms to everybody too, so everybody on the call will get these. You had a couple more slides. You want to hit these?
Yes. For those of you who work with tenants or you're a tenant, encourage tenants to participate in mediation. Reinforce the importance of calling the mediation center immediately, because if you don't schedule within that 10-day period, the landlord can move forward with eviction. Remind tenants to answer their phone calls. The mediation centers will be proactively reaching out to them. Help tenants understand the importance of notifying the mediation center in advance if they can't attend the scheduled mediation. And tell tenants to only reach agreements they can realistically complete. Tenants shouldn't agree to things they can't live up to, because remember, if they default on the agreement, not only can the landlord move forward with the eviction process, but the landlord can then ask for the fees and costs of participating in mediation. Next slide. Final benefits of mediation. It's informal. You heard David say it's not an adversarial process. It's not like going to court. A mediated agreement will help the landlord and tenant avoid court, so it's less costly for landlord in money and time. And what's important is the tenant doesn't have an eviction on their record, which is going to make it difficult for them to find a new place to live. Landlords and tenants make the decisions in mediation. It's not the mediator. It's a final chance to create plans to avoid eviction, and it can help build stronger relationships between landlord and tenant. So hopefully in the future, they can talk to each other directly if issues arise that make it difficult for a tenant to pay. So mediation is a great opportunity to talk through the issues informally with the help of a mediator, avoid the eviction process, ensure that landlords are paid, and give tenants the opportunity to either remain in the rental housing or have enough time to find another place to live. Thanks, Jesse.
Awesome. Well, thank you so much, Tracy. All right, we'll turn it over to you, Judge May.
Thank you, Jesse. Thank you, Tracy, and thank you, David. Good afternoon and aloha to everyone who's joining us on Zoom. If you are feeling overwhelmed, know that you're not alone. It's going to be okay. There are over 280 people on this Zoom, and everyone is trying to understand the new law, understand what's expected of them, whether they're a landlord, a tenant's attorney, a landlord's attorney, or a property manager. It will be okay. We'll get through it together. For this portion of the program, I'm going to talk a little bit about the court process. And the good news is the court process isn't going to change very much. Summary possession cases, which are commonly known as eviction cases, are heard in district courts statewide. For those of you who are not familiar with the courts, the state courts are organized by circuit and division. There are 4 circuits that correspond to the 4 counties. First circuit is Oahu. Second circuit is Maui, Molokai, and Lanai. Third Circuit is the Big Island, and the Fifth Circuit is Kauai. Each circuit has different practices regarding scheduling, hearings, in-person and remote appearances, but the laws and the rules apply equal in all 4 of the circuits. My portion of the presentation will focus on the First Circuit on Oahu because that's where I am a judge. Summary possession cases progress through several phases. The first phase is the filing and the service of the complaint. The second phase is the returnable hearing. The third phase is the pretrial or status conference. And the final phase is trial. There are thousands of summary possession cases filed throughout the state every year. Each year, there are over 2,000 cases filed in the district courts. So we'll start by talking about the first phase, which is the filing of the complaint. The court case is initiated when the landlord files a summary possession complaint with the court. The complaint is filed in the circuit and the division where the premises are located. In the First Circuit, which is Oahu, there are 5 different divisions: Honolulu, Ewa, Kaneohe, Wahiawa, and Waianae. Court staff issues the summons and sets the returnable date. In the First Circuit, the returnable dates are set on designated dates at each division. Cases in Waianae are heard on Tuesdays. Cases in Wahiawa, Wednesdays. Cases filed in Ewa, Thursdays. Cases filed in Kaneohe, Fridays. Cases in Honolulu, also on Fridays. It is the landlord's responsibility to serve both the complaint and the summons on the tenant. The second phase of the case is the returnable. In the First Circuit, parties may appear for returnable in person or remotely at their option without having to file a motion unless otherwise ordered or specified by the court. If at the returnable date the landlord has not yet served the complaint, the landlord can request a continuance and a new court date. The landlord would then have an amended summons issued and file both the complaint and the amended summons on the tenant. Now, if the complaint has been served and the tenant does not show up at the returnable, default is entered and the landlord may request a writ and a judgment for possession. The writ is the legal document that authorizes the sheriff to remove the tenant from the premises. If the complaint has been served and the tenant shows up at the returnable and the tenant admits to the allegations in the complaint, a writ and a judgment by confession could enter. If the tenant denies the allegations, the court will then set a status conference. And the status conference is the third phase of the summary possession case. The purpose of this portion of the case is for the parties to engage in discovery, which typically involves exchanging documents, asking each other questions, and in rare occasions, perhaps taking depositions. Parties also have an opportunity to explore settlement and prepare for trial. In the First Circuit, parties may appear for status conferences in person or remotely without having to file a motion unless otherwise ordered or specified by the court. So I'll talk a little bit about how the law works now and about how things will slightly change after Act 278 goes into effect. So currently, when the parties come to the returnable, parties are typically referred to mediation. Mediation on Oahu is referred to the Mediation Center of the Pacific. The court then sets a status date, typically about 4 to maybe 6 weeks after the returnable date. Once Act 278 goes into place, it is anticipated that most landlords and tenants will have gone to mediation before the returnable hearing. However, if the mediation has been scheduled but has not yet been occurred, the court will likely take that into consideration in determining when the status date will be set. If mediation was not held, the court might still order mediation, or if mediation was held but no agreement was reached, Act 278 gives the court discretion to order additional mediation if the court finds good cause. District court will then set a status hearing. At the status hearing, the court might also set a trial date, the deadlines for the parties to exchange exhibits, to disclose their witnesses, and deadlines to file motions. Now, you might ask, why do we have all of these deadlines? Why does all of this need to be done before trial? The purpose is to ensure fairness, to avoid surprise, and for judicial efficiency. If parties were not required to exchange exhibits ahead of time, and the rental agreement was 50 pages long, and the tenant had 87 different receipts showing that they made payment, it might take hours for the parties to review those documents for the first time while they're in court at trial. By exchanging exhibits ahead of time, everybody can be prepared, everybody can be ready, and there are no surprises. If the court sets deadlines and the parties don't follow those deadlines, the parties run the risk that their exhibits will not be admitted into evidence or that additional witnesses will not be allowed to testify. The final phase of a summary possession case is trial. In the First Circuit, parties and witnesses must appear in person for trial. In the First Circuit, trial is bifurcated for possession and monetary damages. Bifurcated is just a fancy word to say the first half of the trial is held on one day and it's only about possession, meaning whether or not the landlord is entitled to get the residential property back. The second trial, if one is had, would then be on the determination of monetary damages. That portion looks at the amount of unpaid rent, any potential property damage, any issues with regard to late fees, and other things. At trial, each party is responsible for bringing their own witnesses, for bringing their exhibits, including copies for the court that the court would keep. Bear in mind that exhibits should be in hard copy or in some other format that is readily accessible that will be retained by the court. As an example, people often refer to text messages and email messages. Those documents need to be printed out. It would not be sufficient for somebody to come to court and hold up their cell phone and say, see, here are all of the email messages, here are all of the text messages, because those can't be taken into evidence. And I'm quite sure that no one wants the court to hold on to their precious cell phones, tablets, and laptops until the case is completely done, until the time for an appeal has expired, and then to ask that those documents or to ask that those things be returned to them months or even years later. Additionally, it's important that if the parties or their witnesses will need a language interpreter, the parties need to request an interpreter in a timely manner. Waiting till the day before trial or the day of trial is not a guarantee that somebody is going to be there to assist. If a court interpreter is requested, there is no fee for the parties to have that court interpreter there. It's also important that the parties abide by court rules, including the rules of evidence and the district court rules of civil procedure, even if they are not lawyers. Finally, I want to mention that summary possession cases are civil in nature. They are not criminal in nature. So for those who are tenants, the court cannot refer you to the public defender's office or appoint an attorney for you, regardless of a tenant's financial circumstances. Now at trial, the plaintiff, meaning the landlord, has the burden of proof. The landlord must prove their claim by preponderance of the evidence. For this reason, typically the landlord will call its witnesses first, and the tenant will have an opportunity to cross-examine. Once the landlord presents its case, the defendant can then put on its case by calling its witnesses, and the plaintiff then has an opportunity to cross-examine the defendant's witnesses. These trials are all bench trials, meaning they're decided by a judge. They are not decided by a jury. Some final things that I want to mention is it's important and encouraged that the parties maintain open communication. By the time a case comes to court, there is a legal dispute, but to the extent that the parties might disagree with each other's positions, it can be helpful if they are not disagreeable with each other. Remember that it's never too late for the parties to try and settle, because circumstances can change between the time that the parties go to mediation and they end up in court. For example, a tenant who did not pay rent because he or she lost their job might find a new one. A tenant who is going through a divorce might find a potential roommate and might be able to explore a modified lease agreement with a new roommate. A tenant might apply for and receive rent relief. On the landlord's end, the tenant might come into a tax refund, which might give the landlord a little more breathing space to explore an agreement and still be able to make their mortgage payments. Likewise, a landlord, after considering the relationship that they've had with their tenant, might decide to try and give it another go to work with their existing tenant rather than incur the uncertainty and expense of a vacant unit and trying to find another tenant. I'd like to leave you with some resources available to everyone. One is the judiciary website. The website is www.courts.state.hawaii.hi.us. There you can find a number of court forms, including the forms for summary possession cases. The Act 278 forms are not yet uploaded, but it is anticipated that they will be ready by February 5th, 2026. The judiciary also has a chat bot called Kolo Bot. That's on 24/7, and people can get basic information about court hours, where to file things, and other things by using that chat bot. And finally, the judiciary has an e-reminder service. It's a free text reminder service that people can sign up for. Additionally, for those wanting legal advice, the judiciary has the Access to Justice room at the Honolulu District Court. It is staffed by amazing volunteer attorneys, all of whom are licensed to practice law in the state of Hawaii, and all of whom receive training before they volunteer at the Access to Justice Center. Similar services are available on Maui, Kauai, and Big Island through their self-help centers. Additionally, the judiciary has ho'okele services that provides legal information, not legal advice, Monday through Friday, 7:45 to 4:30. So with that, I'll turn it back over to Jesse. Thank you very much.
Awesome. Thank you so much, Judge May. Really appreciate it. Okay. Last but certainly not least, we've got Danny from Catholic Charities Hawaii, and super happy and fortunate to have you here to talk about potential resident resources and stuff for our residents in need. And hopefully we can help avoid people even getting all the way to mediation and everything as well, too, if they're in need in that. So we'll turn it over to you, Danny. Thank you.
Thank you. Hi, everyone. Thanks for having me today. I'm Danny Geller with Catholic Charities Hawaii. I am the program administrator for our housing assistance and referral programs. Next slide. So because we have so many types of financial assistance programs, I kind of wanted to focus more on what we have for statewide programs, being that there's a lot of landlords and tenants here that could be, from different islands. I'm going to kind of start off with some of the newer programs that we have. Some of you might already have heard of the Hawaiʻi Relief Program that we just recently starting to administer statewide. The only thing is Maui is probably the only one we don't administer. That one is through MEO, Maui Economic Opportunity. But for the most part, we administer for the Big Island, Kauai, and Oahu. So for this program here, it is for families that have minors in the household. So to be eligible, they would need to have a minor in the household. The good thing about this program is it can help with pass-through rent and even ongoing rent. So families, households could get up to 4 months of rental assistance. Keep in mind, the program does have a cap. The cap is pretty generous. It's up to $6,000 a month. So families potentially could get up to $24,000 in rental assistance. So for this program here, families would need to go to our website, catholiccharitieshawaii.org. You can kind of see it on the slide here. They would go to the website. There is an online application form that they would need to fill out. So they could go there and fill out the application. Now, because we have such a high volume of applicants, if there is a certain timeline that needs to be met, the program may not be able to meet that timeline. Some of the folks that maybe applied maybe a couple months ago might only be getting contacted now. So the amount of applications that we are receiving are very high. So kind of keep that in mind if you are referring families to apply for the specific program. Another program that we have, I'm going to kind of skip around here and kind of focus on what's kind of relevant for today. We have our state homeless emergency grants program, also known as Chee. So this one helps families and singles. So this one is a statewide program that we have throughout the state. For this one, they're either at risk. So of course, most of the families here are at risk of losing their housing, and they're needing help with their arrears. Funding availability, keep that in mind. We might not have the amount of funding needed to resolve the housing crisis that the family may have. But most times we have worked with landlords and tenants who may have a mediation agreement. We may look at the agreement to see if it's doable, and we might be able to kind of like fill in the gaps. If a tenant is paying a certain portion, we might be able to use a program to kind of fill in the gaps to kind of help them pay the balance down. So we kind of look at this if we're not able to help with the whole balance, but if our assistance will help pay the balance down a little bit faster to where the family can still pay, and it's going to save their housing, then we can use the program to kind of assist with that. Some things that we might consider though, if a landlord is going to evict the tenant anyway, regardless of receiving payment or not, we might not be able to assist. We might not move forward, and we might help the family move versus staying in that unit. So the idea is if we are going to assist, we want to make sure that we can keep the family in the housing and kind of work with the landlord and the tenant to resolve the housing crisis in hopes that the family can remain there, and then in hopes that they can renew their lease. Let me see if I'm missing anything else. So same thing, we look at to see if the plans are doable, if it's realistic as well. We'll look at that as well too, to see if it is affordable for a family to actually stay here. Most times the amount is so high, families end up just moving out. So that's where we kind of can still step in, help with a security deposit, and help them relocate to a new place. If you have any veterans, we do have veterans program as well. Same criteria as far as eligibility or what type of assistance they can help with. It's just that they would need to be a veteran. Hawaiʻi Relief Program, they need to have a minor, 17 years and younger, to be eligible. The SHAKE program, the State Homeless Emergency Grants Program, is for singles and families, so we would help both. So depending on your tenants, if they have children or not, if they're just single adults, that's how you would refer to the appropriate program. I kind of want to touch real quickly on the rent supplement program. If folks are able to resolve their arrears, they might be able to qualify for the rent supplement program. It is a shallow subsidy up to only $500, but they get it for a whole year. So in order to be eligible though, they can't have any arrears, but it's a possibility that we can look at signing them up for the rent supplement program if we know we can clear their arrears. And then that way that might be able to help supplement some of the burden, right, on paying the rent. So on our website, if you go to our website, catholiccharities.hawaii.org, you'll find the links for the rent supplement program and the Hawaiʻi Relief Program. So again, Hawaiʻi Relief Program is just for Hawaii County, Oahu, and Kauai. If you live on Maui, you would go through Maui Economic Opportunity, so MEO for that. They can also call our helpline at 521-HELP, and they can choose the option for financial assistance. Keep in mind too, certain counties might have other programs that can assist. I'm just kind of going over more of the statewide, but there is other programs that we do have. So when you do call that specific office location, they can kind of go over the different programs based on your situation, and you might be able to get a different kind of assistance than what I'm presenting today. Okay. Thank you.
Awesome. Well, thank you so much, Danny. Really appreciate that. And thank you to all of our speakers who joined us, Tracy and Judge May and David for putting all this together. We've got all their contact information or their organization's contact information available. I did answer a couple of the questions in the chat. We will share the slide deck with everybody. I'll email that out along with the forms that Tracy provided. And as well as answering the roughly 20 questions that are in once we can run them by everybody. So many mahalos to everybody for joining us. And yeah, super excited to see this opportunity to be able to bring the public and private sectors together so we can all work together and ultimately help our residents for this. So that being said, we are 5 minutes beyond and we'll wrap up. And This is Jesse Miller with Pacific Housing Association saying mahalo. Thank you, everybody.